dear participants, a very warm welcome to all of you and a very good afternoon to you. So, as already, I think Sir has already shared with you, the topic of my presentation is IPR or Intellectual Property Rights and Patenting. So, I will be giving an introduction to intellectual property rights, and in the rest of the session, I will be covering about patenting. So in the presentation, I will be giving an introduction to intellectual property rights, what are the different types of intellectual property, then about a patent, and then how to file a patent. Now, dear participants, all of you are aware of what do you understand by property. Many of you or most of you must be having some property in your name. Let us say you buy some property in your name, you buy some house in your name or in your family member's name, so that you call as a property and you owe that property. So, but if you see, for buying that property, you have to undergo certain process. You have to register that property under your name, you go to the registrar's office, you do some paperwork and you register that property in your name. Then you can say, okay, yes, now this property is in my name. Like Indra madam is here, so she can say that Indra madam has bought this property and this particular house is in name of Miss Indra ma'am. But similarly, now when you have bought that property, that house, now you can do whatever you feel like with that house according to the rules. If you want that, you do not want to allow some other person to enter it, so it is up to you. So based upon this concept, there was another concept known as intellectual property. You know, what do we understand by intellect? Intellect means anything which is produced by your mind, your creation of the mind. So based upon that, many years back in 1890s, they thought, okay, if somebody is having some intellect, that means it should belong. If he has some creativity of his minds, then he should also have a right to own that property, that intellect property. So basically, if you just see these two words, intellectual property, it is the property created by the intellect of human mind having some commercial value, which can be of some importance. And the legal rights associated with the intellectual property are called the intellectual property rights, which we call as IPRs. The legal rights associated with the intellectual property are called as intellectual property rights, or which we call as IPRs. So this is what they thought about, and it was the importance of this intellectual property was recognized in this Paris Convention for the Protection of Industrial Property in 1883 and the Berne Convention for the Protection of Literary and Artistic Works in 1886. Both treaties are now administered by World Intellectual Property Organization. What I mean to say is, this is an organization which is looking into all these rights, WIPO, WIPO. So it initially started with the industrial property, then it took place further for the protection of literary and artistic works. So intellectual property rights are like any other property rights. But like I gave you an example of a house, if a house belongs to you, you have to undergo certain process. Similarly, if some intellect is, if you are possessing some intellect of your mind, then you have to undergo certain process which are covered under intellectual property rights. So for the first time, this organization, they started this process. Okay, if you have something important, if you have created something important, then you should have a right to own that. But before that, before this 1883 or 1886, before this, any work which was done, that was not protected. Now these days you all are aware that we have these copyrights. If you write something, if you have some novel, if you write something, or if you have some, if you publish some paper or something like that. But before these years, when this WIPO was not there, WIPO was not there, then everything was open. That means any paintings or any novels which were written before this time period, they are free to be used or copied by anyone. Like Shakespeare novels anyone can copy it and make a play or write or adapt it or make a movie out of this. But whatever was done after that, that is protected by the rights. Now, what are the different types of intellectual property rights for our country? These are divided into these subheadings, 7 subheadings. First, all of you, some of them are, you must be aware, patents. Then you all are aware, since you all are from academics, you must be aware of these copyrights. Then some others are geographical indications, trademarks, industrial design, layout design of integrated circuits, and plant breeder rights. I think most of you must be aware of patents, copyrights, trademarks, and industrial design. The other one are certain common, but these 3 or 4 are directly connected with the academics. Now, starting with the patent, dear participants, a patent is an exclusive right granted by the government to the original inventor, developer, researcher of an invention, which forbids others from using, making, or selling that invention. So please see here, patent is granted by some government or some country or some government or some state, right? So that means, that is why you must have heard, I have got an Indian patent, I have got an Australian patent, or I have got an American patent. So it is granted by some or government or by some country. So in our country, if you file a patent, it will be known as an Indian patent. Electric lightning patents held by Edison. I have given these 2 examples. Edison held these patents of electric lightning. Then patents held by Apple. Apple has so many patents. Whenever they make new product, they file a patent so that nobody else can copy it without their permission. So this is what the major advantage of a patent. That is, if you register that patent or if you file and you are granted that patent, nobody can copy your patent without your permission. So we will be studying this patent in detail. But now, next, before that, let us understand the different types of other rights. Now, what is copyright? So, copyrights, all of you are aware, copyrights are a set of legal rights that are granted by law to the writers or creators for different forms of artistic, literary, and scientific work. See, many people are, lot of people have some artistic, creative works they have created. They write, they are good at writing certain things. So all these come under the copyright. So copyright covers literary works such as novels, poems, plays, films, music, artistic works, drawings, paintings, photographs, sculptures, and any architectural design. So you can protect your writings or these things with the help of a copyright. Now, dear participants, you must be aware, if any of you have written some paper, any one of you have written some paper, published
Yes,
any
madam.
paper?
Yes,
Virappan sir.
yes, madam. Published many articles.
So when you publish an article in a journal, they send you a copyright form.
Yes, madam. A
So
copyright transfer form they will ask.
what is that, sir? What is the purpose of that then?
I think that is the benefit for that publisher. We are giving that rights from my side to the publisher side, so that they can use that. I think. I understood that.
Very true. Very true, sir. Very true. He is right. Virappan sir is right. When you publish a paper to a journal, they ask you a copyright transfer form. It is actually, Virappan sir has rightly said, it is actually now if I have done some study, I have done some research. Based upon that research, I have written a paper. When I go for publishing that paper, that means now that publishing house has full right, basically that is why they get it signed, so that later on I may not claim otherwise. So they get a copyright form signed from the authors. Okay, whatever I am claiming now is owned by that publishing house. So that publishing house has full right to publish it on behalf of our name. So Virappan sir is correct. So that is why they are writing, so that later on there are no legal issues that we are writing. But now they are doing another things also. If I am copying, right, you all are aware of this plagiarism thing which is going on. So if I am copying something from somebody else's paper, that means that I have to take permission from either the author or from the publishing house. So now they are taking it the other way also. That means if I have written, like Virappan sir has done some study, I want to quote Virappan sir's study, some figures, then I will have to take permission from Virappan sir, or sometimes they ask from the uh, or from the what do you call, the publishing house or the journal, that yes, I give permission to you to publish my this photo. So that is wonderful. So that is why when you transfer this copyright, that means now you have given the rights of your work to somebody else. That is the purpose of that copyright transfer form. But dear participants, if you are doing some research and if you plan to write a patent, file a patent, then you should not publish your work. I will tell you in more detail when I am telling you about the patents. So then you cannot go for publishing that patent. Don't go for publishing if you your paper, if you want, okay, yes, your study is very worthwhile and you want to file a patent for that particular study. So rights related to copyright include those of acha. Rest other things are like these movies which are done in their performance, producers or phonographs. So they will not go for patent, but they are covered under the copyright. In the recordings, broadcasters in the radio and television programs. Under this copyright comes books, audios, video cassettes, which cannot be reproduced without the permission of the owner who holds the copyright. Now, these days, you all are aware, we hear sometimes or the other, okay, this music has been copied by somebody and they have filed against that particular music house. So these days, the rules are very stringent. In older days, people did not used to copy it freely, but you cannot now copy anybody's music. You cannot now copy anybody's novel and convert it into a movie. All of you must have seen this movie, Three Idiots. So
Yes,
this
ma'am.
Three Idiots, yes, Three Idiots movie is adapted from Chetan Bhagat's novel, Five Point Someone, if somebody has read that. So in that particular novel movie, Chetan Bhagat has given his rights to that movie makers, and he must have taken some reward or maybe some amount that yes, you can adapt or you can convert my novel into a movie, but for that I want this much money or this much share from the movie. So that means the creativity which is done through his novel, that has paid with the help of these rights. So this is an advantage, that if you have created something, you can also earn if you have protected it through some these rights. So moving further, the third thing is your trademarks. Now, trademarks, dear participants, you will see these trademarks everywhere. If you see around you, if you see, just give it a minute and just look around yourself and try to identify some trademarks which you can see. Like I am giving you this session and I am sitting on this in front of this laptop. I can see a trademark of HP. So that is a logo or trademark of Hewlett and Packard, the laptop company's name. So I will give you one second, 1 or 10 seconds. Check any trademark which you can see near you. Maybe you are wearing some shoes which are having some trademark, and write it in the chat box. Basically, trademark is a distinctive sign that identifies certain goods or services produced or provided by an individual or a company, right? So whenever a new product is launched, or suppose your students want to launch their new product, so the first thing they do is they find or they give it a trademark, but you have to register that trademark in the the office, relevant office. So once you register that trademark, then it will be in your name, then nobody else can copy your trademark. So let us see in the chat box if somebody has written the different, yes, participants, please write any trademark which you can see around you, surrounding you, or maybe if you are wearing some. thing which is having trademark. Oh, okay. Pooja Puri ma'am has liquor. Okay, she is having a laptop of Lenovo and Ada. Another she has written. Yes, participants, please tell. See, this trademark which thing has a lot of significance. These trademarks are registered. Is when you register, go to the registers for registering this. Okay, B Aras silk sarees. These are the Bata shoes. Okay, good. Munir sir, Nike, Puma, Coca Cola, or somebody is having Coca Cola also. McDonald also somebody ate. Voltas AC. Okay, great, great. So all these are trademarks. Nike shoes. Okay, Kamaljit Singh ji is saying. So all these trademarks are also for this. When you go to the register this, you have to give specific drawings. Yes, wonderful. Maggie. Maggie also have a trademark. So you have nobody else can copy Maggie, but see, they still try to copy it. Now, when you go to these malls, wherever there is Maggie packet, last time I visited, I saw another packet which was similar to this Maggie packet. It was having similar trademark. But what they do is they make some changes. For example, let me give you an example of Adidas. This Adidas is having 3 lines. It has 3 lines, and in between there is a gap. So what does this is registered that the lines will have this much gap. What these copy people do, they change the gap between the line. So if anybody files a suit, okay, yes, you have copied, they will say no, your trademark registered has this thing, and my trademark registered, my trademark is different from you. So these things they do in the copying. जैसे what else they can do, they sometimes change the color कि your trademark is of this color, or they make a spelling. कई बार आपने देखा है कि कई बार जो ढाबे वाले भी होते हैं, or some shops which are very popular, what they will do, they will copy the name and they will just change a little spelling. Like here Intel is written here, they will change, instead of E they will write I. So they will say, see, your spelling are different, our spelling are different. So this is how sometimes they copy it. So trademark is another intellectual property right, which is there if for a product. Okay, Maggie, Domino's, okay, great. So you can register a trademark. So when you plan, when you your students or anyone plans, okay, I want a new product, I want to launch a new product. So you go for the designing of that product, but it should not be already available. So they will first of all check whether the similar trademark is there or not. If it is not there, you can file it. Now, another important thing is for engineers is the artist's industrial designs, or simply we call it as design patent. So if you have, if you are creating some new design, industrial design, some new design is there, you can also protect it under this heading that is known as the industrial design. So industrial design refers to ornamental or aesthetic aspects of an article. So here also you have to give the design, and that design is then protected. So that means if you have some design and you have protected it through the industrial design registration, nobody else can copy your design. Now I have given these 2 examples of a telephone. This was a very old phone which we used to have in our olden days. And it is, if you see here, second one is iPod. If you remember, when this iPod came, it was a big revolution. So this was the design of the iPod. So iPod design may consist of 3-dimensional features such as the shapes or surface of an article, or 2-dimensional feature such as patterns, lines, or color. Right? So you can register it under industrial designs. So another thing is under IPR is geographical indication. What is geographical indication? Geographical indication is a sign used on goods that have a specific geographical origin and possess qualities or a reputation due to that place of origin. Most commonly, a geographical indication consists of the name of the place of origin of the goods. Now, dear participants, there are certain things which are some specific to a specific place. For example, in this northern India, especially in Punjab, Haryana, and certain parts which were in Pakistan now, which are in Pakistan now, this special type of rice is grown here known as basmati rice. Now, basmati rice is in an indication, is a specific to this place, and this is actually known as then the geographical indication. So, geographical indication means if anything is comes under the list of geographical indication, nobody can claim it's at their own. You cannot file a patent for that. If some of you are aware, few years back there was a lot of row. One US citizen, they though they were Indians only, but they were US citizens. They started growing basmati in USA, and they tried to patent that basmati rice under their name. See what would have happened if they had patented that. That means we could not grow basmati here, and every time if we grow basmati or try to sell it, they would have claimed that patent. So there was lot of hesitation and lot of from the Indian community retaliation against this, and we tried to stop them, and later on they agreed, and they tried to then do it under certain other name, Tasmati rice or something like that. So this is a additional advantage of geographical indication. Means if something is covered under geographical indication, you cannot patent it, it is protected. I have listed some geographical indications like Darjeeling tea, which is grown in tea which is grown in Darjeeling, that will be known as Darjeeling tea. It is not that you grow it here, you say I am growing it in Shimla, this is Darjeeling tea. No, the specific humidity, the specific climate which is present in Darjeeling, and the tea which grows there, that will be known as the Darjeeling tea. Similarly, I have listed 2-3 more, but here again, participants, I would like to have your input. Like I have written some other Kanchipuram sari, Nagpur orange, Kolhapuri chappal. I would like to take your input of any geographical indication which you think is specific to your own area, to your own region. Like I have written certain geographical indications. I would like to the participants to write the geographical indications of their place. Like in Patiala, we have this Punjabi Jutti is very famous, or Patiala Prandi is very famous. So, dear participants, any geographical indication of your place or some place which you have visited, you may unmute and tell, or you may write in the chat. Let us see this as a small exercise. So we will be able to know many geographical indications of different places. We have so many participants and so many different remote centers. Okay, Amritsari Papad. Yes, very true. Amritsari Badiya also. Pooja Puri ji, are you from, I think, from Punjab? So Amritsari
Yeah.
Badiya also.
Yes, ma'am.
Okay, Pooja Puri ma'am. Whenever we visit Amritsar, we try to buy that badiya also. Saints from Kanoj. Okay, Saints from Kanoj, Kowai cotton sari. This is the first time I have seen read, sir. Bhuvaneshwari sir, wonderful idea. Oh, Amritsari kulche. We love food, Amritsari food. Harvinder Singh Malia ji, Amritsari kulche. Wonderful, wonderful. So we have lot of participants from Amritsar also. So I would request you, if any of you want to visit Chandigarh, you are most welcome to attend that program. Kindly register on the website. We will be teaching you how to patent everything detail about IPRs. Oh, Hyderabadi biryani. I love this biryani. Once I got a chance to visit Hyderabad. So the taste which we get in Hyderabad, the biryani taste, that you cannot find anywhere else. Wonderful, Hussain sir. Wonderful. So all these mouth-watering dishes have been written as geographical indications. So see, this is an advantage to us. Now nobody else can copy your biryani and later on patent it or register it in their name and say that I want to sell this, now it is under my name. So that is the advantage of this intellectual property rights. Under this, there is a column geographical indication. So if you think this particular thing is a geographical indication, you have to register it in the geographical indication office so that it will be protected. So already there is a long list where many articles are covered under geographical indication. So this is the advantage of this geographical indication to safeguard our rights. So moving further, we have these layout designs of integrated circuits and plant breeder rights. So layout designs and integrated circuits uh, of an integrated circuits layout designs. See, these days we know it is a age of these computers and electronic devices. So if you have designed a new layout for a circuit, integrated circuits, any semiconductor from the previous one, maybe you have made some new innovations in that, so that also can be registered. Similar to this, there is another right for the farmers. If they have some new breed, some plant breed, if someone has created some new plant breed, the farmers, so they can also save or they can also protect it under plant breeders rights. So, dear participants, these are the different intellectual property rights which I have given you briefly, told you about them briefly. Now, moving further, now we will move to the main part of this presentation, that is the patent. So, what is a patent? Patent is a set of exclusive rights granted by a sovereign state or intergovernmental organization to an inventor or assignee for a limited period of time in exchange of detailed public disclosure of an invention. So please try to understand here, it is a right given to you for protecting your innovation, but you have to disclose that invention. You will tell that this is what I have invented, but nobody can copy that invention without your permission. So, an invention is a solution to a specific technological problem and is a product or a process. So, what is an invention? Invention means it is a solution to a technological problem. You can only file for a patent if it is solving some problem. This is very important. And in India, the protection is provided for a time period of 20 years, because after 20 years we think that after 20 years that patent that will be, now after 20 years now it is open and the technology has gone old, now anybody can use that patent. So what, why, now the question will come, what is the need of this patent? Patents provide incentives by recognizing their creativity and offering the possibility of material reward for the marketable inventions. Now, if you have some patent in your name and you have patented it, filed it, and it has been granted in your name, now what you can do, you can also earn from that. You do not want to convert it into a technology, you have done one patent. So what you can do is you can transfer the rights to somebody else, and you can or in other words you can sell that patent to somebody, and in return you can ask them, okay, this is my patent, this is the invention I have done, you can take the invention, but you have to pay this much money to me, or you have to give this much percentage of the profit to me. So this is the necessity of the patent. That means if somebody is doing so much research, he is using so much of intellect, then he has a right to that particular thing. See, this Apple people, Apple company, the Apple phones, the Apple other articles we are getting, these laptops and all, they put so much money in R&D, and once they get some product, they patent it. Now, why do they patent it? See, they have already spent so much of money in R&D, now they want to get some profit. Otherwise, it will be very simple. They have done so much of study. Now they have brought one product. Someone will copy it. Someone will simply copy it and start selling it at a lower price. So where does they earn? So this is a way of protecting your invention. So the incentives encourage innovation, which in turn enhances the quality of human beings. If someone knows that if I do some good research and I have a patent, then I will earn, they will get rewarded, then obviously it will lead to more patents. So patent protection means an invention cannot be commercially made, used, distributed, or sold without the patent owner's consent. Nobody else can use it. Patent rights are usually enforced in courts. If somebody uses it, then you can go to the court. So you must be hearing that Samsung versus Apple, Hyundai versus Mercedes, they have copied their pet, so they have filed a petition against them. So then you will have to go to the court and they can ask you for damages. So in foreign countries, they ask for so much of, they sue you, and they ask for penalty charges, so much you have to pay in return if you copy somebody's patent. Similarly, a court can also declare a patent invalid if somebody else challenges it. A patent owner has the right to decide who may or may not use the invention for the period during which it is protected, and patent owners may give permission to or license other parties to use their inventions on mutually agreed terms. Owners may also sell their invention to someone else, and once a patent expires, protection ends and the invention enters the public domain, that is after 20 years. So, dear participants, in each country has certain lists which are not patentable. So, in our country also, there are certain things which you cannot patent. Now, these things are, so there are certain things, certain categories which you cannot file for a patent. Anything which is frivolous, or that claims anything obviously contrary to well-established natural laws. There are certain laws, first law, second law, energy cannot be created nor be destroyed likewise. So, which claims anything obviously opposite to natural laws, that is not patented. An invention which is contrary to law or morality or injurious to public health. If you make some new dangerous thing or injurious to public health, you say, I am making a new poison, it will kill you in 5 minutes. So that is not patentable. The mere discovery of scientific principle or abstract theory. Now, sometimes we do some theory, some mathematical model you make, you have some scientific principle, you create some theorem. They will not be covered under patents, but they can be covered under the copyright. The mere discovery of any new property or new use from a known substance. Already a substance is there. You have just created something new, that is not allowed. Already a machine was there. You just changed the circuit diagram a little and you produced a new output, that is not allowed. A substance obtained by administering two different, there are two elements, and it is known that if you mix these two elements, one is base, one is salt, if you mix it will create a neutral thing. So that is already known to you, that is not patentable. Similarly, arrangement or duplication of known devices, that is not patentable. For example, you have a air conditioner, there is a compressor, there is a condenser. You remove the compressor and you say, see, I have made this compressor, it is doing this alternate work, that is not patentable. In our country, we do not allow patents for any method of agriculture or horticulture, any invention related to atomic energy, and any procedure for surgical or curative work. If you are doing some surgery in a new process is there, that is not allowed. And lastly, plants and animals are not allowed to be patented, but certain microorganisms can be patented. This I have already told you. Mathematical or business models and literally dramatic, musical, artistic works, television productions, method of performing mental art, and these all will come under these copyrights. Presentation of information, like I am presenting this information, somebody claims my PPT is very good, I am giving you a wonderful presentation, that is not patentable. Topography of integrated circuits, that is also not patentable. And last, very important fact, traditional knowledge is properties of the traditional knowledge are not patentable. Here I will like to give you an example. Like all of you are aware that haldi in our country has been used since many years, and it is well known fact that it has some antibiotic advantages, and it is used as an antibiotic. So it cannot be patented. But there was a row some regarding this haldi also, they were about to patent it. So this last presentation I was giving, so somebody asked this same question, can somebody patent a haldi? So we cannot patent a haldi, but what these other peoples are doing, they are making the product. If you are using some product out of this haldi, then they are using it for a patent. Here I will like to give you one example. During this second wave of COVID, now we all went through this very bad period, black period. Yes, as an antiseptic or antibiotic, ma'am. Yes, Rajveer Kaur ji is saying haldi is used as antiseptic as well as antibiotic. So I will give you an example. My husband, he was hospitalized for this COVID second, when this second wave came, and for 10 days he had to stay in the hospital, and he had to undergo all those things which they were giving, the medicines and all, when there was shortage of medicines also. So after 10 days when he came back, it was a private hospital, they gave him one medicine to for increasing the immunity. So it was a tablet, box which was having a number of tablets, 10 to 20 tablets, and it was very, very expensive medicine. So we took that medicine. So they said that it will boost your immunity because you have undergone this COVID. So when we came back home, so we checked, we said and read that but we can patent. Yes, that is what I'm telling you, Hussain sir. So what they were done on that medicine, it was written that it is having US patent. That means nobody can copy that medicine, and it was very expensive. So when we read the ingredients, all of you will be shocked. The two main ingredients in that were, when we checked the scientific names and converted them, one main ingredient was turmeric, that is haldi, and the second one was black pepper, that is kali mirch, which we call as. So using our two Indian, already we in India we are using haldi as antibiotic or antiseptic, or this haldi and black pepper. Turmeric and black pepper were the two main ingredients. Using those two ingredients, they had patented that medicine. There must be some other ingredients also. But see what the people are doing. Using these things, they are, so these rules are very important. Tomorrow they will use our traditional knowledge and they will patent it and they will start selling it. That means you, if you are using haldi in your ingredients, if they suppose this patent your haldi, you will end up paying them for each time you are using haldi. So this is what has to be stopped. So that we were very short case, see, they have patented this medicine, and the two main ingredients we are already using in our country. So this is a small incident I wanted to share with you. So dear participants, here today I will tell you briefly about how we can patent our inventions. So these are the, I will just give you a basic idea behind this. So first of all, if you are going for a patent, you will first of all have to check whether your patent or whether your discovery is fulfilling these four things. Now these four things are novelty, non-obviousness, it should have industrial application, and it should involve an inventive step. Some people call it as merge these two as non-obviousness and involve an inventive step. But this is the basic criteria which any invention must meet in order to deserve a patent, in order to file a patent. पहली चीज जो देखनी है आपने, the first thing you have to see is should be novel. Novel means it should be new. The technology you are saying, it should be new. It should not be obvious. Not be obvious means, जैसे let me give you an example. Now we have a chair, wooden chair is there. If I put wheels on it, it will become a wooden chair. It will become a moving chair. So you cannot go, okay, now I have put wheels on it. It was obvious, if you put a wheel, it will start moving. You cannot file a patent for that chair. A carpenter or anyone, it is obvious to everyone, it will happen. But if that chair is used with some other innovative step for some new application, then it has some industrial application. Maybe you have made some chair with some new innovative ideas. Maybe it is working with remote or some other thing for some particular type of patient. Then you can file a patent for that. So the inventions which can be patented, it should have some inventive step, it should not be obvious, and some application. See, you are making some product, but it is not applicable for anything. You cannot use it. So what is the advantage of patenting it if it cannot be used? Nobody will buy your patent either. if you cannot have, if it is not having any industrial application. So this is the prerequisite for a patent. Now moving forward, how to file a patent. First of all, the first step we have already seen, check if your invention is patentable, that we have checked. Now this means that you need to check if another individual has filed a patent for the similar technology for which you are filing. Now here performing an in-depth patentability search is required. Now after that you will have to see whether the patent which you are claiming anyone else has done that or not. If somebody else has already done the same invention, then you cannot go for a patent. So invention has to be new, but before filing for a patent you will have to check the entire database. Okay, this is the thing I am claiming, I am making this new thing, but I have to check, you have to check whether the same thing has already been done or not. This is known as the in-depth patentability search which is required. So this is known as in-depth patentability search. So if you are filing, we will discuss here only Indian patents. So if you are filing a patent, you will require these forms. Indian applicants need to fill Indian patent application form number 1. This is form number 1. For every patent filed, form number 2 has to be filed, which is known as patent specification. And you can choose between a provisional and complete patent application based on the stage of invention. Here you have a choice. Sometimes what happens, suppose your students or you are already doing some research and you have started you have started doing some work, but it is still under progress. You have the idea, but you have not completed it. But you are afraid, okay, if you do not file, somebody else might not file it before you. So for that, you can undergo a provisional patent, you can file a provisional patent applications. So this is clear that if it is still if you are still testing an invention, so you can file for a provisional patent application. For this, a period of 12 months is provided to complete the invention and file for a complete patent. The step 3 is the publication. See, participants, if you have even done these two steps, step 1 and step 2, that is you have filled form 1 and form 2, your patent would be published. So patent application after expiry of 18 months from the date of filing will be automatically published in the patent journal. But the patent applicant can request for a patent to be published earlier than also by paying a fees. During this period, now, if you find any patent which has been filed, if you think that this is not correct or something is wrong, then somebody can also oppose your patent. After the publication of the patent application, until the grant of patent, any person can file an opposition to the patent application. It makes sure that unless the opposition is set aside, the patent cannot proceed. Now the next is, so these steps are over. That means successfully you have filed a patent, and now you can claim one step, that is you have successfully published your patent also. Now the next step is request for examination. They will not examine your patent until you send them a request for examination, which we'll call as RFE. So the request has to be filed within 48 months from the date of filing of the application or the date of priority, whichever is earlier. Request for examination fees is around 4,000 to 20,000. And now I will show you the website for this also. All the fees, everything is present there. So you can check the fees from there. After the thorough examination of the patent examiner issues a first examination report to the applicant. So after that, you get a FER, first examination report. They will check your report and they will find out the mistakes, problems, or any queries which they have in your report, and they will put those queries to you, and you will have to answer those queries. Only if you have successfully answered those queries, your patent will be granted. So once the examination of the patent is conducted, the FER objections have been fulfilled, then you are eligible, then you will be given a patent. So they, like you have a judge in the court. Here also there is a controller who if he is satisfied he will file, if he is satisfied with your responses, he will grant you a patent. Now, before moving further, I will stop here. If you have any questions, after that, I will show you a case study of my own patent, as well as the patents, some patents. I will show you the forms also which you have to fill for filing a patent. But dear participants, there is also a renewal fees after the expiry of the patent. Each year you have to pay some renewal fees also to keep it alive. We call it as a renewal fees to keep your patent alive. So these are the forms, form number 1, 2, 5, 26 and 28, which are required. But before moving to the forms, if anyone is having any question, yes, like folding chair, very good, Hussain sir. Already the chair is there. Now you have put some arrangement and you are folding it. You cannot patent it. But if it is some innovative thing is there, then you can patent it in your name. Okay. Any questions from anybody? Otherwise, we will move forward and we will see what type of patent can be registered in case of social science research. Ma'am, it is not subject specific, Pooja ma'am. Like I will give you an example of my work. I have done some work in material science. I have we had taken 2 3 powders and produced a new powder, but there I will show you now my patent also. Now, but there the objection which was created by controller was that you are mixing 2 powders and a new powder is there. Admixture of 2 powders is not allowed. But then we showed them there is a new inventive process involved, so then we got the patent. The subject is not relevant. You have to make something which has some industrial application. Like we filed a patent and it was used for a coating, and its application was that it will reduce the heat transfer rate, or it will increase the life of the tubes. So it is not that it is which research, it is that it should fulfill the criteria which we are saying. Then definitely you can file for a patent. So these are the forms. Any other question before we move to the forms? Here I will be telling you brief. We can patent our questionnaire applied in research. Sir, questionnaire, anything writing, that will go under copyright. Questionnaire you have designed, you can copyright it. You can protect it through copyright, but not through patent. Is for industrial application. Anything which goes into the writings, even some mathematical model like पूरी मैम, अगर कोई आपने मैथमेटिकल मॉडल बनाया है, जैसे हम लिखते हैं ओनली, कोई दैट विल गो अंडर कॉपीराइट, दैट विल नॉट बी पेटेंट. कोई आपको प्रोडक्ट चाहिए, कोई एप्लीकेशन चाहिए उस थिंग की, जैसे आपको मैं एग्जांपल देती हूँ. फॉर एग्जांपल, यू राइट अ न्यू प्रोग्राम, कंप्यूटर एप्लीकेशन, some computer program you write, that cannot be patent, though it is new, novelty is there. But if through that computer application, एक आपने new computer program बनाया, but using that computer program you have made a new device, वो application लगा के आपने वो एक नई device पे लगा दिया, then you can patent it. जैसे हमारे ये घरों में कोई न्यू बेल लगाई हुई है, कोई वाटर मैनेजमेंट बेल, ये जो आपके टैंक्स के ऊपर है, उसका कोई आपने न्यू मेथड लगाया है, न्यू प्रोग्राम करके, बट दैट इज अ न्यू एप्लीकेशन, then you can patent it. Questionnaire you can go for copyright. Questionnaire can be protected. आपने बनाया है, आपकी मेहनत है, you can do. Creative work, yes. Anything creative comes under copyright and invention comes under patent. Creativity कोई की है, वो आपके copyright में आएगा. Okay, Rajiv Kumar ji is right. So participants, if you are really interested, you can attend this program. Here we will be actually calling the patent people from Punjab state of council for this patenting is there, and some patent consultants also we will be calling if anyone wishes to attend it. So I have already shared it, but I will share it in this chat box also. Now let us move forward to the various forms. Form number 1, 2, 5, 26 and 28 briefly. These are the forms which are required. All these forms are available on this website I have given you at the bottom. So form number 1 is an application for patent grant. Form number 2 is the patent specification form. Form number 5 is declaration to be filled with complete application. Form number 26 is the patent authorization patent agent. See, I am not so good in writing the language of the patents. द अटर्नी, इसमें आपको थोड़ा क्लेम्स की तरह लिखना पड़ता है. सो व्हाट आई कैन डू, आई कैन हायर एन ऑथराइजिंग पेटेंट एजेंट. जैसे आप प्रॉपर्टी में पावर ऑफ अटॉर्नी दे देते हो, पावर ऑफ अटॉर्नी टू समवन, here also I can have some authorized patent agent. For that there is a form number 26. I can authorize him कि you correspond with the patent office and I will on my behalf, everything can be done from that. So that is done through form number 26. There is another form number 28, mandatory only if you are claiming small entity or startup status, then there is a form number 28. Through this form they give you some fees also. If you have done some prior art research from somebody, then they give you some partial fees also is covered under this. So let me share these actual forms with you, and let me show you the website also where all this data is present. So dear participants, this is our ipiindiagovernment.in. Here you can see about us, history of Indian patent. This is intellectual property right, our website. And here, this is under Department of Promotion of Trade and Internal Trade, Promotion of Industry and Internal Trade. Here you will see all the forms. Can you see all the forms? Form number 1, which I told you, application for grant of patent. Form number 2, provisional complete specification. And form number 5, declaration. Then form number 26 and 28, which are relevant to us. There are all other forms. If you want to do your work faster, that is there. If you want to have a section 8 company, some other forms are there. But these forms which I have shown you, these are enough for filing a patent. So you can check from here form 1, form 2, form 3. But for you, I have downloaded these forms. I will show you these forms as well as the forms which I have. The forms which we have filled for that. So this is form number 1. This when you will download it, you will see this form number 1 here. This type of form is there. This form number 1 is actually the application. जैसे आपने कोई छुट्टी लेनी है, कुछ अप्लाई करना है, तो एक एप्लीकेशन लिखनी पड़ती है इनिशियल. So this is the initial application कि I want to file, this is my name, this is the type of application, these are the inventors, these are the persons, like this. So first form you have to fill is form number 1. Then you download form number 2. This form number 2 is, let me show you form number 2 also. Form number 2 is the form where you will tell कि yes, I want to file for a provisional, or whether you want to go for provisional or complete. Here you will give the entire specifications. I will show you one example also. You have to give the specifications of your entire patent. Okay, what are the specifications of your patent? This is form number 5. The form number 5 is the form which is to be given as a declaration. Here you will give a declaration that I am the sole owner and I want to I have done the invention and I declare that the invention has been done by me only. So you declare here. So form number 1 is an application. Form number 2 is the specifications which you have to give, and form number 5 is the declaration by the inventors. And form number 26 was also there, which tells you that I give this I give this power of attorney to somebody else. So dear participants, this is the filled form number 1 when I applied from my previous institute along with Indian Institute of Technology. These were the inventors. So we were the inventors, and these are the authorized persons to whom we have given that on our behalf you can file our patent, Lal, Lahiri and Salhotras. So this is the form number 1 which we had filled, and this is the form number 2. This is form number 2. I will show you for some other patent. I had filed one patent on behalf of the institute. So in this form number 2, you have to give the entire specification. जो आपने discovery करी है, for example, this was one patent, system and method to prevent accelerator overloading. तो ये file हो गया था, this was filed. So here you have to give the entire background. जो specifications हैं, the specifications of your patent that are most important, you have to specify the details. What invention you have done, this is the background of the invention, right? What are the innovative steps you have taken? What was the problem in the existing problem? What is the prior art you have done? Prior art means similar type of work was done, similar type of accelerator was there, but this was the problem in that. And in our new invention, this is the new which we have done. See, when you are searching, you will search whether similar work has been done or not. If similar work has already been done, you will have to tell your claim, what is the new work which I am claiming here through this. So specifications are most important. You will have to tell that already no patent is there in Indian database because we are filing for an Indian patent, and you will give a summary of the invention, and you will also give the, if there is any drawing, you can give the drawing of the patent also, of your product also. Then the abstract of that. So this is how you file for a patent. In this you will have to give the claims. The patent जो आपको होता है वो claims होता है. I claim this, 3, 4 or any number of claims which you have. So this is the form number 2, participants. I have shown you one example case study of file number form number 2, which includes all the detailed specifications, right? And form number 26 is the form which is, through this you give the, this is form number 26. I authorize this person, whoever is your agent or person, I authorize that person to file the patent in our name. So we had authorized certain agency, some agencies, some attorneys. So now legally they can file the patent in your name, but the claim will be yours, right? So if you are successfully filed the patent, then the patent will look like this. If any one of you have got a patent filed in your name, so this was the patent, I got my patent, this was the name of the institute, and it was in the name of the inventors. आप institute के नाम पे भी कर सकते हो. The institute will be the patentee and you will be the inventors. So my guides, Harpreet Singh, Niraj Bala, Prakash Singh, Satya Prakash ji. So erosion corrosion resistant cold spray coatings for boilers, this was the name of the patent. We filed in 2013, but that at that time the process was very slow. When we filed in 2013, it was granted in 2019. So it took, see, 4/1/2019, it took so much of time, but now the process is very fast. Now in 2 years or 3 years the patent is granted. So the date of grant of patent is there. The patent will be live for only 20 years. After that, anyone can copy it. So this is the form number, these are the complete specifications. Like even if you are doing some research, the patent which I filed for my patent, we were doing PhD at that time, and from the PhD work, I had one part I had sent for the patent. But dear participants, when you are doing PhD, the first thing which comes into your mind is, okay, yes, we should go for publication. Let us publish a paper. But do not go in for that. First of all, if you publish any paper, that means you have already published it in domain, then you cannot patent your discovery or your invention. So do not go for any publication, do not disclose it. Only then you will be able to file your patent. So this is the file, the specifications of my patent. It was a bit lengthy, it was a research work. So this was covered under this. So I have shown you my patent also. If anyone is having any question, we can have your questions. Otherwise, I will now show you the website from where you can also search the progress of your patent, where your patent has reached, or if you want to search anything else also. But before that, if anyone is having any query related to that, you are most welcome. Want to ask something? So if I share this presentation with you, I will share the links also. At the end of my presentation, I have given certain links. You can copy these links. Like first link I have already shown you, and this is the link through which you can do any search for the patents. Let me show you this link also. And you see this here, if you know the title or if you know the application number, you can check the progress of your patent. For example, for my own patent, let me see the number, what is there. 305383. Let us see, if you go on this website, I have checked the patent number 305383. Okay, it has been granted to me. So it is not published, but it has been granted. So select search field, patent number, put this captcha. What is this, L? I or L? I think it is L. See, when I put that patent number 184 del 213, the entire patent application number has come here. See the details of my patent. See, madam, you were asking social sciences. My patent has been done under chemical. It was under category of chemical. So you can see the application status from here. Suppose you have filed a patent, you want to know. So you can also view the documents. So this is the name, applicant name, institute name, name of this ordinary application. So you can view this. So all the documents also you can check. Right? So I have given this, I will share the presentation with sir. So I have given this link here if you want to search for any patent also. So very simple, you go on this website link and you can put, if anyone is having some, anyone has filed a patent, you just give the application number, and if it is only public, you can also check whether it is published or not. So you can check it from here. So I have given the link for that. So to even so this is there. Even participants, there is a patent facilitation facilities state-wise also, like I told you, and centrally also. If you see here, I have given the link for that also. This is DST uh, also has a patent facilitation center, like the patent which we filed and for which the patent was granted. We got this patent, all the fees, all the expenditure was borne by DST because it was under a project. So DST, through this facilitation center, they provided us the entire grant. So this is the link I have provided for this Department of Science and Technology Patent Facilitating Center also there. So if some of your research, if your certain research is through this, you can also contact them, TIFAC, Technology Information Forecasting and Assessment Council. This is the Patent Facilitating Center. They can help you in filing a patent, and the entire fees, as I told you, for our patent, the entire fees was borne by them. So I have given the link of this in the presentation also. You can contact this list. So I think I have, in brief, covered all the aspects of the IPRs and patenting, and I have given the links also. And this is the last website. This is for the startups. If you are registering yourself under a startup, then they also pay you for the fees, for that other fees. Fees means when you are doing some prior art, or if you have some attorney, if you are appointing some attorney, so some fees of that is covered through this. So dear participants, this is all from my side. For another 5-10 minutes, if you have any queries, we can take your queries. If you want to ask something related to that, anything you want to know about patent or IPRs, so we can discuss.